Trump is facing a legal tsunami that just became undeniable. Newly unsealed Epstein documents totaling 437 pages were released by a Manhattan federal court on February 1st, and legal experts are calling this the most damaging documentary evidence to emerge in years. These aren't vague allegations. These are sworn depositions from eyewitnesses, phone records verified by telecommunications companies, flight manifests with signatures authenticated by forensic experts, and calendar entries from Epstein's personal files. When federal prosecutors describe these documents as establishing a sustained pattern of contact during the period when criminal activity was most active, you know the legal walls are closing in. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this release that has criminal defense attorneys scrambling? U.S. District Judge Loretta Preska ruled on February 1st that public interest in transparency outweighed privacy concerns, specifically citing ongoing investigations into whether additional individuals participated in criminal conduct. This isn't just another controversy. Within 24 hours, 3 congressional committees announced investigations. 2 state attorneys general opened inquiries, and legal analysts across the political spectrum agreed this represents the most serious documentary challenge Trump has faced. And believe me, when legal experts from opposing camps reach the same conclusion about evidence severity, something genuinely catastrophic just unfolded. Here's the full picture of what's been building. Tensions around Trump's Epstein relationship have existed for years, but remained largely speculative due to limited hard evidence beyond photographs. But everything changed on February 1st when Judge Preska ordered unsealing of materials sealed since 2016. The cache includes depositions from 14 witnesses who worked at Epstein properties between 1998 and 2005, phone records from 3 telecommunications providers, flight logs from 4 different pilots, and scheduling documents showing arrangements for meetings. According to court documents, testimony establishes Trump's presence at Epstein properties on at least 29 documented occasions between 2000 and 2004, starkly contradicting Trump's assertions that he barely knew Epstein. One witness, a former household manager identified as John Doe 89, testified to 17 separate instances when he observed Trump arriving for private meetings. His deposition includes specific details. The vehicles Trump arrived in, times of day, usually late afternoon. The detail that refreshments would be prepared because Epstein knew Trump preferred Diet Coke and specific snacks. These are not details of casual acquaintances. Smash that like button if this is making sense so far. Here's where legal implications become genuinely serious. When attorneys reviewed these depositions, they recognized this wasn't just reputational damage. This was potential criminal exposure. On February 2nd, a bipartisan group of 27 House members held a joint emergency session. The group included 16 Democrats and 11 Republicans. A senior Republican congressman stated the documented evidence was substantially more extensive than anything previously known. A Democratic ranking member called the phone records particularly alarming and requested Justice Department briefing. By February 3rd, they'd sent a letter to Attorney General Merrick Garland. The 6-page letter uses extraordinarily direct language, demanding answers about whether Trump was ever questioned about his Epstein relationship and whether any statements he made are contradicted by the newly unsealed evidence. Drop a comment right now if you saw this coming. I read every single one. Now, the documentary evidence becomes absolutely devastating. The materials include phone records showing 89 separate calls between Trump Tower and Epstein's Palm Beach residence between January 2001 and December 2004. The billing records show 23 of those calls occurred between 10 p.m. and 2 a.m. Multiple calls exceeded 30 minutes, including one on June 12, 2003 that lasted 52 minutes, another on August 4th that lasted 41 minutes, and a third on October 29, 2004 that lasted 1 hour and 14 minutes. These weren't brief check-ins. Legal analysts noted late-night calls of this duration suggest a relationship far beyond casual acquaintances. What makes this exponentially more serious is newly unsealed testimony from 2 of Epstein's former pilots, David Rogers and Larry Visosky. Both testified under oath that Trump flew on Epstein's aircraft on multiple occasions. Rogers testified to 9 separate flights between 1997 and 2003. Visosky testified to 6 flights between 2002 and 2005. The flight logs include passenger manifests with signatures. 3 independent forensic handwriting analysts all confirmed the signatures matched Trump's known handwriting. The manifests show flights from Teterboro to Palm Beach on March 12, 2000, from Palm Beach to LaGuardia on November 8, 2001, and at least 8 additional domestic flights through 2005. This sent immediate shockwaves through legal circles. When 2 pilots testify under oath to multiple flights, when telecommunications companies produce billing records showing 89 calls, and when forensic experts confirm signatures, the claim of minimal contact becomes legally indefensible. This isn't the first time Trump's Epstein connection surfaced. Think back to July 2019, when Epstein was arrested on federal trafficking charges. Trump told reporters he had a falling out with Epstein 15 years earlier. That statement received significant coverage, and many outlets reported it as definitive. The key difference was absence of documentary evidence to challenge Trump's timeline. Then in December 2021, Ghislaine Maxwell was convicted on 5 federal counts. Trump's name was mentioned briefly, but no direct allegations against him were presented. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And during the 2016 campaign, a lawsuit was filed alleging assault at an Epstein property in 1994. That case was withdrawn before any findings. Throughout these events, Trump maintained he barely knew Epstein. Now, however, the situation is fundamentally different. We're dealing with 89 documented phone calls from billing records, 15 documented flights testified to by 2 pilots under oath, passenger manifests with authenticated signatures, and sworn depositions from 14 witnesses describing 29 observed visits. The pattern is unmistakable. When phone companies, pilots, and multiple unconnected witnesses all provide documentation that aligns, denials collapse under evidence weight. So what makes this release constitute a genuine legal tsunami? According to former federal prosecutors who reviewed the unsealed documents, the materials create several distinct categories of legal exposure. Barbara McQuaid, former U.S. Attorney for the Eastern District of Michigan, told MSNBC the documents established Trump's public characterization was materially and demonstrably false. She explained materiality becomes crucial if Trump ever made statements to federal investigators or provided testimony in legal proceedings regarding his Epstein relationship. If any such statements exist and contradict this documentary record, prosecutors could potentially charge false statements or perjury. Here's the kicker, according to multiple legal experts. The documents include a deposition from Sarah Kellen, one of Epstein's assistants. Kellen testified that Trump's personal assistant would call to coordinate meetings and occasionally include requests about which guests would be present on particular dates. She testified both Trump and Epstein understood these were planned private meetings, not random social encounters. This testimony directly contradicts the casual acquaintance narrative. Don't go anywhere. The most explosive legal implications are coming next. And here's what should alarm everyone focused on rule of law. If a presidential candidate and later sitting president maintained extensive documented contact with a convicted sex offender during years when that offender's criminal enterprise was most active, if that contact included late-night calls, coordinated meetings, and numerous flights, and if all that was systematically denied for nearly 2 decades, the question of what else was concealed becomes unavoidable. This creates an impossible legal position. On one side, Trump faces mounting documentary evidence from neutral third parties. That means either acknowledging the relationship was far more extensive than claimed, which raises questions about what Trump knew regarding Epstein's activities, or arguing that 89 phone records, 15 flight logs, and 14 witness depositions are all somehow fabricated. On the other side, Trump must explain to voters and potentially prosecutors why denials were so categorical if documented truth reveals 89 calls, 15 flights, and 29 visits. And here's the legal trap prosecutors immediately identified. There is no middle ground. Either the records are accurate, in which case previous denials were knowing falsehoods, or there's a conspiracy involving phone companies, pilots, and household staff, which no reasonable person would find credible. Legal experts across the spectrum are describing this as a credibility crisis with serious criminal implications. Andrew Weissman, former FBI general counsel and lead prosecutor on the Enron task force, told CNN that while these documents don't prove Trump committed any crime related to Epstein's conduct, they unequivocally establish Trump's public statements were false. Weissman emphasized falsity matters enormously if Trump ever made similar statements to federal agents. Under federal law, making false statements to investigators is a crime even when not under oath. Renato Mariotti, former federal prosecutor, added these revelations create a cascading legal exposure problem. Once documentary evidence contradicts a narrative this thoroughly, Prosecutors in multiple jurisdictions may feel compelled to investigate whether false statements were made in their cases. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, George Washington University law professor, who has frequently defended Trump's positions, acknowledged on Fox News that the documentary evidence is substantial and troubling. Turley stated that while he doesn't believe evidence shows Trump participated in Epstein's crimes, the extent of documented contact makes Trump's prior characterizations inaccurate at best. So let's break down what this legal tsunami actually means. First, immediate criminal investigation risk. These documents will almost certainly trigger new federal and state investigations. The Southern District of New York, which prosecuted both Epstein and Maxwell, will face pressure to determine whether additional individuals should be investigated. The documented contact makes Trump a logical subject for scrutiny. State prosecutors in Florida may open investigations under state trafficking statutes. Second, massive congressional inquiry complications. House committees have announced investigations involving subpoenas. If Trump is subpoenaed to testify about his Epstein relationship, he faces impossible choices. Refuse by invoking Fifth Amendment rights, which has obvious political implications. Testify and maintain previous characterization, which would be contradicted by 437 pages of evidence and could constitute perjury. Or acknowledge far more extensive contact, which invites questions about what he observed and why he denied it. Any option creates damage. Third, civil litigation exposure. Attorneys representing Epstein victims told reporters they're reviewing documents to determine grounds for new lawsuits. If witnesses testify they observed Trump at Epstein properties when trafficking victims were present, those victims may have grounds to depose Trump. Even if Trump is never accused of criminal conduct, being forced to sit for depositions about what he saw would be politically devastating during a campaign. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond immediate legal risks, this raises fundamental questions about truth and accountability. Presidential credibility on personal conduct goes to whether our systems can function when basic facts are disputed. When a former president can maintain for 2 decades that a relationship was minimal, and then documentary evidence shows 89 phone calls, 15 flights, and 29 visits during 4 years, we've moved beyond political spin into territory threatening truth itself. If evidence this extensive can be dismissed, the foundation for accountability crumbles. This has created panic within Trump's campaign. According to reporting in Politico, the New York Times, and the Washington Post, Trump's legal team held emergency meetings throughout February 2nd and 3rd. Meetings reportedly became contentious. Some attorneys advocated acknowledging more extensive contact while emphasizing no knowledge of criminal activity. Others argued any acknowledgement would be catastrophic, instead recommending attacking the unsealing decision. The campaign remains fractured. Meanwhile, polling data suggests this is cutting through. A CBS News poll found 61% of voters said the evidence made them more concerned about Trump's judgment. Among independents, 71%. Even 22% of Republicans expressed concern. Things escalated when Trump responded through Truth Social posts and a campaign statement on February 3rd. He called the unsealing a coordinated hit job by Biden's Justice Department working with radical left judges to interfere in the election. He claimed evidence was manipulated and based on testimony from people paid to lie. The statement insisted Trump barely knew Epstein, that everyone in Palm Beach knew everyone else, and that he had nothing to do with Epstein's crimes. The posts personally attacked Judge Preska. Stay with me. What comes next will completely change how you understand the legal stakes. Here's what makes this response legally problematic. Trump's statement doesn't address the documentary evidence substance. It doesn't challenge telecommunications records' authenticity. It doesn't dispute flight logs. It doesn't explain how 14 different witnesses provided testimony describing the same pattern. Instead, the response attacks process and claims persecution. Legal experts note this is significant. If evidence were fabricated, a competent response would say so directly. Attacking judges while not disputing actual documents suggests the documents are authentic but politically damaging. Jennifer Rogers, former federal prosecutor, stated Trump's response was strategically incoherent legally. Continuing to characterize the relationship as minimal, facing 89 documented calls, doesn't make evidence disappear. It creates additional false statements prosecutors could use. This goes far beyond one set of unsealed documents. The fundamental issue is whether our systems can maintain integrity when documentary evidence contradicts narratives sustained for 2 decades by powerful individuals. If a former president can deny a relationship while phone companies have 89 calls and records, while pilots testify to 15 flights, while 14 employees describe 29 visits, while forensic experts authenticate signatures, and if that president faces no consequences, we have established truth is optional and evidence is irrelevant. Once that precedent becomes normalized, there is no foundation for accountability. If this blows your mind, hit that like button right now. Here's what we're actually confronting. 437 pages of documents established through phone records, flight logs, witness testimony, and authenticated signatures that the Trump-Epstein relationship was extensive, sustained, and included late-night calls, numerous flights, and coordinated meetings over years. This is about whether telecommunications records, passenger manifests, sworn depositions from 14 witnesses, and forensic analysis matter when they contradict a politically powerful figure, when courts release evidence, when phone companies produce records, when pilots testify, when experts authenticate signatures, and when multiple witnesses provide corroborating testimony, denial becomes legally untenable. If there are no legal consequences for maintaining a narrative this thoroughly contradicted by documentary evidence, facts are negotiable and evidence is decorative. Keep close attention because this is developing rapidly. More attorneys representing Epstein victims are reviewing documents for grounds to file lawsuits. Federal prosecutors in Southern District of New York face pressure to reopen investigations. Congressional committees are preparing subpoenas for additional documents. State bar associations are receiving complaints demanding investigation of whether attorneys made false statements in legal proceedings regarding Trump's Epstein relationship, and voters are watching to determine whether evidence this extensive will have any consequence. Before we go any further, smash that subscribe button so you never miss content like this. Here's the reality right now. 89 documented phone calls between Trump and Epstein over 4 years, including 23 late-night calls. 15 documented flights with signatures authenticated by forensic experts. 29 documented visits witnessed by 14 employees who provided sworn depositions. All directly contradicting nearly 2 decades of claims Trump barely knew Epstein. Congressional committees are issuing subpoenas. State attorneys general are opening inquiries. Federal prosecutors face pressure to investigate. And Trump's legal team is preparing for what sources describe as the most serious legal threat he has faced. This isn't just another controversy that will fade by next week. This is documentary evidence that cannot be wished away or dismissed as partisan conspiracy. What happens next will determine whether our legal system maintains capacity to hold powerful individuals accountable when evidence contradicts their narratives, or whether political power matters more than phone records, flight logs, forensic analysis, and sworn testimony from 14 witnesses. The evidence is now public record in federal court files. The telecommunications records exist in company archives. The flight logs exist with signatures 3 forensic experts authenticated. The witness depositions exist as sworn testimony carrying felony perjury consequences if false. Now we wait to see whether truth and accountability still function when documentary evidence this comprehensive contradicts 2 decades of denials. The stakes for rule of law have never been higher. The documentary evidence has never been more specific, extensive, and impossible to dismiss. And the gap between documented facts and sustained denials has never been wider or more legally consequential. Pause for a second and hit that like button if you're finding value in this coverage.